our schedule. And all right, well, thank you everyone for joining us today. Good afternoon. My name is Janine Braxton, and I am the NorCal LERA Secretary. And thank you for joining us for today's fall event, Union Organizing in the Post-Pandemic World. I am going to be serving as one of two moderators today with my fellow colleague and the NorCal LERA board member, Felix De La Torre, who also serves as General Counsel for the Public Employment Relations Board. I'm an attorney in Sacramento, California, and I represent local, regional, and national employers in all aspects of California employment law. And I am very excited for our event today. I know many of you are familiar with our chapter and also with the National LERA from our earlier meet and greet. But for those of you who might be joining us today for the first time or are otherwise less familiar with the National LERA or our local chapter, I do want to provide you a little information about what our organization does. We include the Sacramento and Bay Area regions, and our objectives are to foster better relationships and understanding among professionals working in this space, and also with labor relations, and just to provide a forum for general discussion on emerging trends and legal developments, such as today's topic, union organizing in the post-pandemic world. And we also encourage beneficial and enjoyable interactions among representatives of various fields, including labor, management, which is my background, government, academia, and neutrals. And so with that, I just want to extend a very warm welcome on behalf of the NorCal LERA board and welcome our spectacular panel that we have for you today. We will accept questions later in the program, and we will try to get in as many of your questions as we possibly can. And so with that, I will turn it over to Felix.
Thank you, and good afternoon and welcome. I'll go right to it. I'm going to introduce our first presenter, Professor Gould. I'm going to go through his bio quickly, not too quickly, but I do think it's important people understand the deep history that Professor Gould has in labor. It will, I think, foster questions at the end of the program when you kind of understand how involved Professor Gould has been in labor relations throughout his entire career. So Professor Gould is a Charles A. Beardsley Professor of Law, Emeritus at Stanford Law School. He is a prolific scholar of labor and discrimination law, and he's been an influential voice in worker management relations for more than 50 years. Professor Gould served as chairman of the National Labor Relations Board from 1994 to 1998, and subsequently he's been the chairman of the California Agricultural Labor Relations Board here in Sacramento from 2014 to 2017. He's been a member of the National Academy of Arbitrators since 1970. So as chairman of the NLRB, he played a critical role in bringing the 1994-95 baseball strike to its conclusion. And he's arbitrated and mediated more than 300 labor disputes, including the 1992-93 salary dispute between the Major League Baseball Players Association and the Major League Baseball Player Relations Committee. He's served as a secretary on the Labor and Employment Law section for the American Bar Association. This was 1980 to 1981, as well as an independent monitor for First Group America addressing freedom of association complaints. This was from 2008 to 2010. Professor Gould also served as special advisor to the U.S. Department of Housing and Urban Development on project labor agreements between 2011 and 2012, and as an independent reviewer on equal employment opportunity for the mayor of San Francisco from 2020 to 2021. He is an author of 11 books and more than 60 law review articles, and the recipient of 5 honorary doctorates for his significant contributions to the field of labor law and labor relations. And I'm not sure if his most recent book, A Primer on American Labor Law, which I think has been released or is about to be released, is among the 11, or whether it makes 12 books now for Professor Gould. So anyway, welcome, Professor Gould. Thank you so much for being here. We're very excited to hear what you have to say.
Thanks very much, Felix. Can I be heard? I hope I've unmuted myself. Have I done so? All right.
We can hear you.
I feel as though I the case that I want to spend most of my time talking about here this morning, I feel as though I've had personal contact with it in two ways. This involves the question of non-employee organizer union access to private property, in this case in agriculture. And the Agricultural Labor Relations Board, which was formed in 1975, the time of the Agricultural Labor Relations Act. And one of the first things it did was to formulate a regulation allowing for non-employee organizer access, much more access than is provided under the National Labor Relations Act by Supreme Court interpretations. I feel as though I've met this problem personally two ways. One was that California Supreme Court in the 70s upheld the regulation as constitutional and cited an article that I had, a couple of articles that I had written in the mid-60s about union access to private property, generally supporting limited union access to private property. The other part of it is what Felix mentioned, and that is as chairman of the as chairman of the Labor Board, Agricultural Labor Board, for 3 years, appointed by Governor Brown the second time around that Governor Brown was in Sacramento. So had two cuts of this because I was chairman for 3 years, and in the 3 years that I was there, one representation petition was filed by a union. One representation petition was filed. And by the way, under that statute, the only way you can have recognition is by filing a representation petition, contrast to the National Labor Relations Act. In the summer of 2015, my board conducted hearings to look at the reasons for lack of activity. Now, some of these reasons had already been developed by Miriam Powell in a book called The Crusades of Cesar Chavez, because Cesar Chavez had given up on union organizing fairly early in the statute, and decided that he wanted to do other things that would be more useful. And we took a look in the summer of 2015 at what was going on. We found that, of course, that the majority of the workers were undocumented, and that a very substantial number of them were indigenous. They didn't speak, many of them didn't speak Spanish as well as English. Many of them, particularly on the coast, were completely isolated, didn't have smartphones. They had the old, more primitive phones. The district court, when it dealt with the challenge to the constitutionality of the board's regulation on non-employee access, cited our hearings to highlight the fact that these workers were very, very difficult to reach. And that was part of, in the district court's view, the justification for the regulation. Well, you know that the Supreme Court, by a 6-3 vote in Cedar Nursery, has held that that the access regulation is a per se taking in violation of the Constitution. The taking without just compensation is unconstitutional, and the court said so in a fairly broad fashion. It did. It was called upon to try to reconcile its holding with the ongoing viability of statutes permitting access by government, for instance, to private property for the purpose of health and safety, inspection, meat inspection. There's been a good deal of litigation about that. The Supreme Court said that that's okay. Other kinds of access, the court said was okay because access had always been provided. This made Justice Breyer in dissent to say is the only kind of access that is permissible. And now for the purpose of regulation, that which goes back to the formulation of the Constitution itself in 1789. Well, the opinion is a very broad one, and I think it's going to affect both the Agricultural Labor Relations Act and other labor relations statutes like the National Labor Relations Act, which I was involved in the 1990s. Lechmere against the National Labor Relations Board was Justice Thomas's maiden opinion. He's now celebrating his 30th anniversary, and that opinion, of course, provided in the private sector under the covered by the National Labor Relations Act for the near always perennial exclusion of non-employee access to private property under the National Labor Relations Act. The court retained the idea that it had been first formulated in 1956, that the question of whether or not the unions could have access depended upon the availability of alternate avenues of communication, but the way in which it was formulated clearly left unions with virtually nothing in the private sector. There was, however, one thing that was retained in the Lechmere, and that was disparate treatment. In other words, the employer, if it allowed certain kinds of non-employee activity on private property, might fall within what kinds of activity became an issue unto itself. The Trump board, as you know, and some of the circuits have said, in contrast to my board, that charitable solicitation and the like was not akin to union solicitation, and that did not constitute disparate discriminatory enforcement. Is anything left now of disparate discriminatory enforcement, the other leg of Lechmere? And that depends upon what the court means when it speaks of access which doesn't fall within its condemnation. It said that isolated invasions may be appropriate. Well, what is isolated and what is not? But also isolated invasions which would benefit the employer. The Supreme Court in Cedar Nursery made it clear that it was not of the view that union access under the Agricultural Labor Relations Act was of benefit to the employer. And I think it's quite likely that under other labor statutes, it will come to a similar conclusion, that non-employee access is, even though formulated because of disparate treatment of union solicitors, is not going to be protected any longer under Lechmere. The PRO Act, which you know, is pending now in the Congress. There's an attempt to get portions of the Right to Organize Act, which is, of course, very broad and deals with a wide variety of matters, some of which the administration is trying to tuck into a reconciliation. But one provision in it would outlaw the captive audience. Well, that's not going to hold up under Cedar Nursery. The employer's ability, if that had any chance of being constitutional under the court's earlier free speech cases, clearly the right of the employer to express itself and to exclude others, they're not going to be able to respond to the captive audience either. That is likely going to be unconstitutional under Cedar Nursery. Well, you might say that the court said that traditional access could be provided, but the court didn't regard union access under the Agricultural Labor Relations Act as traditional. You got to go back to what Justice Breyer said. What does it have to be? Back to 1789? The National Labor Relations Act came along 40 years before the Agricultural Labor Relations Act. Is that traditional? It seems not to me. Another exception that was articulated by the court, and that is permits, the giving of permits. In the last few pages, the court said that nothing that we're saying here interferes with the ability of government to provide, to gain access so as to use a permit. And here they're thinking, I think, again, of these health and safety cases, which of course were so controversial when they were first enacted and are controversial in the eyes of some even today, in the wake of the Gilded Age 125 years ago. But permit regulation is going to be allowed. Now, under the Agricultural Labor Relations Act has allowed for jurisdiction to be extended to cannabis. Cannabis is regulated in California through permits. And as it happens, the statute mandates access, non-employee union access in exchange for other kinds of action by the union, which is of a cooperative nature vis-a-vis the employer. Is the cannabis statute constitutional, given the fact that it flies under the rubric of permits? I think that too is going to be a stretch. There's going to be an article coming out in the Harvard Law Review, which I've just in the past 24 hours read for the first time, in which the author maintains that the significance of Cedar Nursery is such that employers will be able to defend dismissals of workers who engage in union activity as inconsistent with their right to any limitation on their ability to dismiss will be inconsistent with their right to exclude. And so that you can exclude people that you don't like, that you don't see as acting in your benefit because they're working for the union, or you can exclude people because of what they're complaining about under Title VII. I don't think that we can say that, this Supreme Court, this is true of the Janus decision, which we'll talk about later on, goes about as far as it can to cabin and limit employee rights as is possible. I'm not sure that, and I don't believe that Cedar Nursery can be read this far, but I do think that employers are going to be arguing not only for the complete exclusion of non-employee organizer access, but for limitations upon employee solicitation, which has been protected by the statute since patent packing ruling of the board and in the early 1940s, and the Supreme Court's endorsement of the right to be able to solicit, and now the ability to have access to email and the internet on private property for the purpose of putting forward your own position. I think we're going to see the next round of litigation begin to focus upon attacks on employee solicitation as inconsistent with Cedar Nursery itself. Well, those are some of my thoughts about the statute, about this interpretation of the statute. The Supreme Court, this Supreme Court has gone about as far as we think it can go, but if we look at decisions like Janus and Shelby County, which held unconstitutional the Voting Rights Act of 1965, but I think they may be able to go a little bit further so long as its composition remains intact.
Well, thank you very much, Professor Gould, for sharing that very detailed analysis of Cedar Point. And with that, I'm going to introduce our next speaker, James Araby. James Araby is the Director of Strategic Campaigns for UFCW Local 5, a 30,000 member union based in the San Francisco Bay Area. Mr. Araby works across Northern California to build political power for UFCW members who work in the grocery, retail drug, cannabis, and agricultural industries. In addition to the political work, Mr. Araby leads UFCW 5's organizing department. In 2019, UFCW 5 was able to organize 500 new members into the union. Mr. Araby also serves on the advisory board at the UC Berkeley Labor Center, is an appointee on California's Interagency Advisory Committee on Apprenticeship, IACA, that's a mouthful, and is a former board chair for Coro, California. Before joining UFCW 5, Mr. Araby was the executive director for UFCW Western States Council, where he helped lead coalitions in California to pass first in the nation laws on paid sick days, banning plastic bags, worker retention in the grocery industry, and regulating medical cannabis. And now with that, I will turn the floor over to Mr. Araby. Thank you.
Thank you so much. And can everyone hear me? Can you give me a thumbs up if you can hear me? Okay, great. And I'm on a bus, so sorry if there's a lot of background noise there. We're out here in Nevada right now, meeting with all the other UFCW locals and employers around the issues related to cannabis, workforce development, and apprenticeship. It's one of the hot button issues that we're really dealing with as we, try to build the labor movement. And it's always hard to follow someone as esteemed as Professor Gould, who I've known for years, and we've sort of gone back and forth on a lot of these issues. So just to sort of give a perspective, not from the legal perspective, but actually from the organizing and union perspective as it relates to the Cedar Point decision, but overall Janus and all these other decisions, as an organizer, I think about every day about how the law benefits organizing. And if the law doesn't benefit organizing, I find a way around it. And I think that's ultimately the perspective on the union. When Janus first passed the Supreme Court, it was going to be the death of public sector unions. No more public sector unions were going to exist. Union membership was going to fall. And while that may have been the case in certain areas of the country, namely when you look at sort of right to work decisions by the legislature or the Janus decision, it did impact the industrial Midwest on a much greater percentage if you look at the drop in union membership. But it actually reversed in some ways. The Janus decision it actually reversed the decline of public sector unionism in a lot of states, and actually membership grew. Because what it did was it actually refocused public sector unions on going out and organizing their members, signing up their members, being creative around the ability for them to communicate to non-union workers and to sign up members and to join the union. And I think the real principled question underlying all of these decisions is, as we look at the opposition related to union organizing, the opposition uses legal frameworks to sort of undermine our ability to have access and sign up members. But at the end of the day, the National Labor Relations Act, the fundamental underpinning of the National Labor Relations Act, which is workers have the rights to belong to a union. As long as that stays in place, as long as we have the ability to go out and have workers join unions, it doesn't matter, in my perspective. Yes, the law makes it harder, but if unions rededicate their existence to actually organizing unions, to actually putting the resources in, not only to representation, but into actually organizing workers, our opposition can do whatever they want. The fundamental underlying principle of workers joining unions can be upheld if unions actually make the effort to go out and organize workers. And I just want to sort of put that on the table. As I look at my job and my role in the union, I did spend over a decade working on the political and legislative side of unions in California. We passed a lot of great laws in California, but underneath it all, it didn't advance the expansion of the union as much as going out and actually being an organizing director, reorganizing the union to put money into and put resources into actually going out and communicating with non-union workers. Now, is it hard to organize? Do these decisions make it harder? Absolutely. I think the ability to, the great thing under the ALRA for a long time was this provision to go out and actually assert access rights into the facility, because, the hardest part is getting in contact to work with workers, right? In a non-union environment, in the private sector under the NLRA, that right has been restricted. So it's more difficult to sort of start the engagement of workers. I can tell you many stories of when I was at SEIU and I would go into hospitals to try to talk to non-union hospital workers, and I would be kicked out of the places in which they work. And that has two effects. That has psychological effect with the workers. Number one is they're going to get in trouble if they talk about the union, even though it's a protected right under the NLRA. It's a protected right to talk about the union. It creates a psychological effect of workers if they see the union organizer getting booted off the property or escorted by security. So it's a psychological effect. And it also reinforces this idea that the union's a bad thing, right? And I think and it allows for employers, the nefarious thing about this is it allows for employers to sort of interject this idea that the union's a bad thing and it's going to create division, it's going to create problems in the workplace. And so those are really the psychological. I think there's a huge psychological impact on these rules more than there is on an organizational impact, because I still think we can overcome that. So access is an important thing to the workers. And so as we rethink the efforts, I think the other thing that's sort of happened in sort of the post-pandemic world, we've been very successful as a local since that we're approaching about over 1,000 workers organized in the last 2 years in our union. We're reversing the decline. We're looking at cannabis as a place. And in cannabis, it's a little different because we do have these provisions under the state law that requires a labor peace agreement, some level of neutrality. So as Professor Gould has sort of inferred, in exchange for the unions, the union to say they will not strike, picket, or cause disruption in the business, the employer will be neutral when it comes to, workers' rights to organize or not. So, and I know there's a lot of question on the legality of that requirement under the California state law. There have been, since California had passed that provision in 2015, it was reasserted in the passage of Prop 64 in 2016, and then again through the regulatory process in 2017, 18, and then today. And it has also moved across the nation in other states. New York now, New Jersey, multiple other states are requiring some level of labor peace. And then it's even further reasserted in California at the local level when it comes to sort of licensing and requirements around licensing. Many cities and counties have passed provisions that we think are actually fairly legally solid in terms of counting points towards an application when it relates to LPAs. So that has given us a sort of a foot in the door, but it still doesn't guarantee the right. It doesn't guarantee that these workers will become union. So I really believe the fundamental underlying principle in all of this is that unions have to rededicate larger percentages of their budget and operating costs to actually going out and organizing non-union workers. I do think other things that we haven't talked about here, but I think are important as we think about labor law in the private sector. We have the PRO Act, that's currently sitting in Congress, And the PRO Act has a lot of provisions that I think will make it easier for workers to see that joining the union isn't a bad thing. I think we have to sort of think about, the fundamental underlying principle is, do we as a country in our law value the rights of workers to have workplace democracy and the impact of workplace democracy, on our economy and other broader things. I think those are the things that we have to really figure out in the law. Yes, there's these questions, these really technical questions around access, around solicitation. There's also questions related to recognition when workers decide to organize. The process is as hard, if not harder, not only when you win the election, but when you actually get a first contract. I just read this statistic. You talk about the pandemic. In 2020, there were actually 694 election petitions at the NLRB in 2020 during the pandemic. Unions won about 70% of those elections, but only 46% of those elections actually have resulted in a first contract. And so think about that for a second. 70% of 694, let's just say roughly that number is around 400. Only 46% of that number actually result in first contracts. So the number in terms of election petitions to contract, it's really about a third of workers, even when they get through the process of actually going to an election. Because 694 elections, mind you, the pandemic, kind of slowed things down. 694 elections for the tens of thousands of workplaces in the United States. It's a very, very small number, which again goes to Professor Gould's point. When he was the chair of the ALRB, California and the ALRA have some of the most favorable terms. I mean, I would love for provisions in the ALRA to be input into the NLRA, the National Labor Relations Act. And yet only one petition was filed in Professor Gould's 3 years of the ALRA. So that tells you what the fundamental underlying problem is. The underlying problem is not the law. Yes, the law creates challenges. The problem really is the lack of desire for unions to put the resources into organizing, to test the law, right? That's the great thing about the law, as many on this call know, right? The law, when laws are passed or even overturned, you can always find new laws, but all of that is generated through organizing, right? And we don't really fundamentally understand the problems of the NLRA that was passed in 1935 and then 1947 Taft-Hartley, and then further cases pursuing that. Well, if we don't organize, we can never really test whether this law works or not. We can never really file appeals or even think about new laws. And I think too many unions have depended on legislation and quick solutions to organizing. As the great Fred Ross Sr. says, there's no shortcuts to organizing. We actually have to go out and do the work. And if we can do the work, then we can change the way that the law is interpreted, and we can win, and we can inspire workers to take action. And I think that's fundamentally where we have to go. These cases only reaffirm my belief that in order for workers to really build the union, we have to put money into organizing, we have to put bodies into organizing, and we have to challenge these laws in a way and create a movement, to get a political movement to get elected officials and legislators to actually reform the NLRA, which I think needs some real reformation, not only in terms of organizing and access and lists, but also in terms of contracts, and all those other things after you are successful. And I'll end with this. If you think about the United States, about 9% of private sector workers are in a union. It may even be less now. Union membership has been declining for a very long time in the US. And I don't think, but if you look at the statistics, the latest poll says 70% of American workers would want to join a union. So here we have 9% of workers in a union, and yet 70% of workers say they want to be in a union. So where's the disconnect? The disconnect is the ability of unions to put money into organizing and the laws that govern those intents. Because if you look at Europe or you look at Canada, who have gone through the same impacts of globalization in the economy, the difference is that they have stronger labor laws, that allow for, even when workers decide to organize the union, that they get into contracts and they can actually be successful at getting contracts and representing workers. So to me, that's the bigger picture. I think this case has an impact on our ability to go out and access workers, and we need to think about that. But I think the broader implication is unions need to put more money into organizing. We need to put more effort into actually, growing the membership and challenging these laws in the workplaces, challenging the ability of employers to dictate terms and really reassert the right that was founded in 1935 and even before then, which is that workers have the right to organize and the right to workplace democracy.
Thank you so much. I appreciate that. With all this information, I got to think there's got to be a lot of questions for our two panelists. So I think at this point, it makes sense to open the floor to our participants to ask questions. So I'm not sure what's the easiest way. Either raise your hand or just unmute yourself and direct your question at Jim or at Professor Gould, and we'll go from there. Robert?
Yes, hi, Felix. Thank you very much, Professor Gould and Jim. I really appreciated your comments. I've got two questions. One is, are you aware of any efforts by the ALRB to confront head-on the just compensation requirement now by the Supreme Court in the Cedar Point's case? I thought about this a lot, and it seems to me that the ALRB could in fact create a regulatory formula to determine what would be just compensation for taking a small area of corporate farming for an hour. And if you take a profit analysis, I mean, we would be talking about a very limited amount of money. And I was wondering whether you had any thoughts about that. And the second question is, recently in California, Governor Newsom vetoed AB 616. And I think that if I am not incorrect about this, Professor Gould, you had some concerns about whether that would be an appropriate piece of legislation. I know that under the National Labor Relations Act, electronic signatures are permissible, but agricultural workers do not. And given the limited access to those workers, I was very disappointed by what Governor Newsom did. So those are my two questions. Just compensation in light of Cedar Point and AB 616 and what we can do about that.
Yeah, I'm the guy who should have some ideas about just compensation. I don't, except, and I don't think the Agricultural Board has done anything on this yet. Maybe somebody over there is thinking about this, but this is going to be, at a minimum, isn't this going to create a good deal of litigation? This is not something that is easy.
Yeah, no, I don't suggest that it might be easy, but I mean, for example, if a grower has 10,000 acres and makes $10 million, if you divide that by 365 days, that's $27.39 a day per acre. And if you divide that by 24 hours, it's $1.14. So there could be a formula, it seems to me, where the ALRB basically turns gross annual earnings from acreage into what it costs for 1 hour for using a small portion of the acreage.
Yes, yes. Now, initially, you're going to, are there or are there not going to be problems in getting access to the employer's financial position? I don't know. I haven't given a lot of thought to this, Robert, but I just kind of intuitively kind of recoiled from it because I was fearful that it contained too many layers of potential litigation and delay with it. Maybe this is, given the importance of access, this is the way to go. Again, the fundamental problem in this area is that, and the point was made in some of the briefs that were filed before the Supreme Court, is that no organizing is going on. And we would get occasionally, when I was there, we'd get these petitions for access, not for the purpose of organizing, but and we took the position that these were appropriate petitions for access also, for the purpose of raising health and safety issues. We thought, okay, these are related to employment conditions. This has a nexus, there's a nexus between this and union activity. We provided access and nobody litigated. But there is, these poor souls are completely isolated. I don't know that there has been more than 1 or 2 petitions filed by the unions, except in cannabis, since I left, which is almost 5 years ago. The other point you raised, tell me quickly what was the other point you raised about the election. No, I'm a great proponent of, as you may know from opinions that I wrote when I was at the board, of postal elections, and I want to create as much flexibility for these elections to take place with ballots being mailed to workers by the board. The concern I had with the bill as written was that it simply allowed, there was only there was no control by the board over, as I read the bill, over the document which would be handed to the worker, and only an opportunity for him to sign, and what he would be signing was not something that was regulated by the board. If the board can issue precise regulations on how people are to conduct themselves through postal ballots, I think that would be a good legislation. And as you know, in the article that I wrote, I said the governor should immediately convene the unions, the growers, interested parties to focus upon this. Of course, it didn't happen. And the reason it didn't happen is nobody cares, because these guys are undocumented. They count for nothing. So long as, unless we have immigration reform, they will continue to count for nothing. The growers have the money. They count for considerable. Governor Brown used to talk to me about the fact that he tried to get some unions to come in and organize the farm workers, you see, because he knew, we all knew, that the organizational efforts were completely moribund. I don't want to talk on too.
Well, I think just to sort of expound a little on that point by Professor Gould, I think there's been in California, if you even look at the legislature, there's sort of this myth of the UFW and the myth of, and I'm not disparaging our brothers and sisters and siblings in the UFW at all, but I do think it's sort of, the peak of farm worker organizing was right after the act was signed. I think in 1977, there were about 150,000 farm workers in the union at the peak. Currently, there's about 30,000 farm workers in the union, into many unions, including our own. UFCW represents some ag workers, UFW Teamsters. There's a couple other, and it is incredibly difficult to organize, as Professor Gould pointed out, because of just the nature of the work and also the people who work in the fields. But I also think there's sort of been this non-binding agreement that until the farm workers prioritize the organizing of these workers, that other unions really haven't looked at that as a viable opportunity to organize, and giving the challenges of the language barrier in particular too is another big thing. But I do think we have to prioritize the organizing in order to really challenge some of these assumptions under the law, whether good or bad.
And I want to, by the way, since if you're going to be Jim, I have to be Bill. None of this Professor. But Jim, I have to echo one thing you said, that I want to say again and again, and that is, you have many people running around the country. And I must say, I was prone to this at various points in my life, being a lawyer, that if you only change the law, that everything is going to change. Well, that just isn't the truth. And the truth is, you need to have, as Jim has said, unions putting the resources into organizing the unorganized. Steve Greenhouse, in his book that he wrote a couple of years ago, and he came out here talking about it, pointed out that in the 1930s, the unions were expending between 30 and 50% of their expenditures were going into organizing the unorganized. And today, he estimates that it's about 10% on average. You know, you've got to have a commitment to organizing, and too many locals. You know, the guys who get the good positions in the local, they want to negotiate the contracts, because organizing the unorganized is really hard work, and we need to have more. They tell me, I don't know enough about it, that Unite has done some of this. We need to have more young people who are the kind of people who came into the movement in the 30s to go out there and organizing. That, coupled with some measure of law reform, I think can change the nature of our society, but not law itself. We're too much tied up in this idea that just abstract reform is going to change things. I don't think it will. These two things have to operate symbiotically.
So I'm curious what your thoughts are about the scope of Cedar Point. I mean, obviously it applies to agricultural settings, but it really is a private employer or a private property issue. And so is Cedar Point going to be a problem for organizing in construction, warehouses? I know that UFCW has tried to organize or has organized packing houses, which are, you know, functions of agriculture, got factories. I mean, you have these large private property industries that, in my opinion, could look at Cedar Point as a way to keep people just outside the gates of these very large properties to stop organizing from happening. And
Well,
do you agree with that?
The point I tried to make in my opening remarks was that although this was decided under the Agricultural Labor Relations Act, the court is speaking constitutionally here. This applies to non-employee union organizer access as a general proposition, wherever a private employer is involved. I think that's why I said that I think that that we thought had some value, who engaged in disparate treatment, had to brought other people in to allow them to communicate, had to be able to bring in non-employee organizers as well. I think that's going to be under attack. I think and I think also that the cannabis provisions providing for access are going to be under attack as well, because even though the statute itself points out how access is to benefit the employer, the court is saying that access is of no benefit to the employer. Why? Because we say it is of no benefit to the employer. That's our view. Just, you can see this kind of thinking go through the Janus decision as well. So I think it has enormous implications, and even though the court is saying that people can provide access through permits, using cannabis as authorizing employers to engage in the cannabis industry through permits, I think that these kind of permits are going to go down the tube under Cedar Nursery. And I think also the employee solicitation cases themselves are going to be under attack, because the employer is going to say, listen, I have the right to exclude anybody who's presenting a point of view on my property that I don't want. It's my property, not yours.
I have a question that was sent through chat, so let me quickly ask it. I was wondering thoughts on the future of unionization of the tech sector industry, and whether that is in reality the next big industry organizing effort that we are on the precipice of. The most recent attempt at a local Amazon and the IATSE Hollywood labor issues that are now dealing with tech companies such as Apple, Google, etc., within entertainment that seem to be new to labor organizing and unionization. Bit of a long question, but I think you get the gist.
Right, right. Who's that? Is that, maybe that's a question for Jim.
I could try to take part of this, and then maybe Bill can take it after. I think that the biggest challenge, I think, when you look at the tech industry, is there's another big legal issue here, and that's AB5 and sort of misclassification of workers. I think this is another major issue in terms of our ability to have the workers' ability to collectively bargain. A lot of the entertainment industry, which IATSE has actually been very successful, and a lot of the other, entertainment unions actually have sort of organized, to an extent under this, under this sort of temporary work provision. The problem is in the tech industry, I think we've focused a lot of the attention in California around Prop 22 and, AB5, and sort of classifying a subset of workers, gig workers, to be permanently classified as independent contractors. But it's not just the delivery drivers that deliver your food that are classified as independent contractors. If you look at Google, over 60% of Google's workforce are independent contractors. So you have a lot of software engineers, Apple, these other big sort of tech companies that use software engineers. The dirty little secret is a lot of those engineers are independent contractors and actually don't have the rights to collectively bargain currently under the law. I would say unions are definitely looking at, the tech industry, but how you define the tech industry is really interesting, because, you could say the person that drives for Uber is a tech worker as much as the software engineer that works for Uber that designs the program, right? And so, but yes, I think we do have to look at, we have to look at all these industries as, where if you look back into the peak of the union's efforts in the, 40s and 50s, which was actually primarily driven by the war, in the federal government's ability to leverage private sector employers to be neutral in organizing, maybe outside of the UAW and their work in the auto work. If you fast forward to today, what are those big industries that are employing, millions of Americans? The tech industry, is in the mix, but, you got to look more at the service industry jobs. The government obviously is a big level of employment. So the goal really is like, what's the fundamental goal of organizing in these industries? And it's really about how do we set larger share of the overall economy. And yes, the tech industry has a big percentage of that, but I also think we're going to look at where the jobs are and how we structure employment, how we cases are important in terms of our ability to access workers and define how people organize the union. But I also think how we structure our work and how we classify work is actually more important in some of these cases. And I don't know if, Bill, you want to sort of take on some of that, because I think that's going to be the challenge for us as we think about organizing in the future.
Yeah, well, it's a very, very big subject. We had this unusual situation in the 30s and 40s, and you're right to point to the fact that the War Labor Board during World War II was so important in promoting unions, and which created this 35% representation in the workforce as of the mid-late 50s. And by the way, the unions can, everybody says, oh, Taft-Hartley is responsible for all this. No, the unions continued to grow in the teeth of Taft-Hartley because of the kind of activity that had gone on in the 30s and 40s, and long after Taft-Hartley. The problem, I had thought, this book that I've written, the new book that I've written is not the primer. I've written six. Everybody's getting sick of that. I've written 6 editions of that, but rather this book called For Labor to Build Upon: Wars, Depression, and Pandemic. And I tried to see if there was some relationship between the crisis that we're enduring now and the crisis that we endured earlier when unions grew. Fundamentally, unfortunately, this pandemic pushes us apart. It's very dangerous for us to be with one another. This is why we have these virtual meetings. That wasn't the case in the 30s. It brought us, desperate circumstances brought us together. And it's quite different. I do think that the dire circumstances of the pandemic have made us focus upon, particularly with the advent of the Biden administration, our inferior social safety net and the fact that we don't have protections for our workers that other industrially advanced countries have. But yes, there've been some union activity, but in the newspapers, intellectual workers have joined, but in the main, thus far, we are where we were. And that is because I think, notwithstanding this big fight that took place at the turn of this century when, the new organization was created, the Andrew Stern led 4 or 5 unions out of the Federation into a separate federation because he said unions weren't putting their money into organizing. Well, that situation continues to exist right now, and we continue to have the absence of law as well. I may have wandered off your initial question a bit as I think about it, because you were, but I don't know, why don't I let you turn it over to you?
Okay, well, let me turn it back over to our attendees to see if there's any other questions that this discussion has generated. Just go ahead and unmute yourself and jump right in. Let's see. Well, while you're thinking of that, I do have another question for you. And this is just about access itself. It seems like we communicate now mostly through text messages, social media, email, chats. Do you think physical access is as important now as it had been in prior organizing efforts, or is the access you now get to people through these technological devices sufficient?
On that, I would say physical access is always important because, the fundamental underpinning of a union is the relationship between the organizer, and the workers. And you can get initial contact through text messaging and Zoom, but you really need to build trust, when you sort of meet and see someone eye to eye. But I will tell you that technologies have made it much easier. We've, through this pandemic, like I said, I've organized upwards of 1,000 workers in the last year. And a lot of that has actually been through programs. We meet with 1 or 2 workers, and then we now have the ability to sign people with the digital authorization card. The NLRB accepts those digital authorization cards. We put together that, we send it out in a text message, we hand it off to our coworkers. And the great thing about the digital authorization card is once the worker signs it, we get an email right away, and we know that they signed the card. The biggest fear of an organizer is always losing those authorization cards, right? And then having to go back and try to find the worker. That's no longer the case. And, we're able to see instantaneously the connections and relationships that each worker has with others as this card goes through. So definitely the pandemic, and unions have to figure out, through Zoom or Google Hangouts or all those other sort of online platforms, as well as using digital authorization cards. It has made, these tools have expanded our ability to reach workers, but fundamentally, we can't give up that one-on-one relationship, because when the boss fights, when the employer fights and threatens people's jobs, you gotta be able to know that you can trust the organizer and the union having your back on these things. And you just don't do that through Zoom and text messaging. You can build that relationship ongoing, but those initial face-to-faces are important. So is access as important? I will never say it's not important, but it's definitely still important.
The Court of Appeals for the Ninth Circuit recently, I meant to pull that out for our session here today, but but the Court of Appeals for the Ninth Circuit has upheld a Washington state statute giving unions contact information of workers excluded from the coverage of the National Labor Relations Act. The employers petitioned the Supreme Court for the Ninth Circuit, upheld the lawfulness of it. The employers petitioned the Supreme Court. A lot of us are kind of holding our breath to see what the Supreme Court would do, whether they would try to jump in as they did under Janus, and they denied certiorari. Now, it may be that they will review this and declare that it is unconstitutional on the grounds that it interferes with privacy rights of employees, which, of course, the court is reluctant to find in other contexts, but it may find it in this one. But I mean, that clearly there is some energy and legislative energy being given to making available information, which becomes more important in this period of COVID.
Thank you. Is there any other questions from the attendees? Okay, well, we've hit our 1 o'clock point, which is the program time. If the speakers want to answer any other questions and can stay on, that would be wonderful. If not, I can just say thank you very, very much to have such an esteemed panel for our NorCal LERA. You didn't disappoint. This was a fabulous presentation. It was everything we hoped for. And I certainly appreciate your time. I know it's hard to get a hold of you guys for an hour, and the fact that you gave us an hour, we're very grateful for that. So thank you so much for your presentations and your information.
Thank you, Felix.
Thank you.
Thank you.